Oh, man, it's not on. Oh, your microphone. Okay. Okay. And everyone was able to let themselves in. That's great. Good morning, everyone.
Good morning.
Happy Friday, the 26th, last Friday of June. We have another COVID month under our belt. We have a calendar today where we'll be connecting with a number of inmates. And I'm happy to handle this in whatever order is most efficient for our colleagues at the jail. I'll open up the little chat window so I can hear from whomever. I see a gentleman. Are you Mr. Miller?
Yes, sir, I am.
All right. Well, so far it looks like we're just going in the order on the calendar, but folks from the sheriff's office, if we need to go in a different order for whatever reason, let me know, and we can gladly do that.
We're going to go straight down.
Straight down the calendar it is. Okay. Thank you so much.
All right.
I'll do the same. So we'll get started. Position 1 is Johnny Miller. And it sounds like we are arraigning Mr. Miller today. Is that correct, Ms. Patel?
Your Honor, I thought we had a plea and arraignment on Mr. Miller, but I could be wrong. I thought to check status for his drug court. Can you hear me?
Now we can, yes.
Sorry about that. I thought that this was regarding whether or not his progress towards drug court had happened. But he had a plea and arraignment, and I believe I filed a waiver of arraignment for Mr. Miller. If not, I'm more than happy to do that.
So I'm looking at Odyssey now, and there was a plea and arraignment 1 year ago. And then there was a judicial hold issued, a warrant. The case was reinstated only about a month and a half ago. So I assume Mr. Miller wasn't available for his plea and arraignment in June of 2019. When Judge Reeder had the case, she put it in judicial hold status at the end of last June. And then the case was reinstated, an order I signed on May 12th because we had tracked Mr. Miller down. So we ought to have you file a waiver of arraignment on his behalf if he does not want to be formally arraigned.
I do want to.
Mr. Miller, so let me do a couple things. First of all, you have a right to be here in court, but you're appearing remotely. Are you comfortable with the fact that you're connecting via Zoom and waiving your right to be here in court?
I am comfortable.
Okay. You also have the right to have your lawyer, Ms. Patel, by your side. That would be the normal setup. We can't do that in this setting. She's here, and I can have you two have a private conversation if you need to. I don't think that'll be necessary for what we're going to work through today. But I do need to make sure you are comfortable proceeding and you're waiving your right to have Ms. Patel in your presence for our conversation today. Do you waive that right?
Yes, sir.
Okay, so let me take a step back. The entry on the calendar is correct. Mr. Miller is actually before us for arraignment or waiver of that arraignment, but it would be great if we talked a little bit about drug court as well, if that is a natural next step for Mr. Miller. I see there was a repeat offender notice filed in May of 2019, and by the district attorney's count, Mr. Miller has 16 felony convictions. Most of them are from long ago, some before some of us on this call were born, but some more recently. So Mr. Miller's got a situation we ought to try to work through that may be more complicated than simply death by taking. Do you know anything, Ms. Patel, about the status of a drug court interview, referral, anything like that?
I followed up 2 weeks ago and they indicated that they're just trying to gather his records right now. They said that he looks like a good candidate, and I've pre-tried this with Ms. Hall already. And so I don't see any issues as long as the medical's clear. I think that that's one of the only things that's in the way right now.
Okay, I assume this would be a track 3, although we don't call it that anymore. There's a new name for it on the new referral form that I think we call it a probation track as opposed to a diversion track. Is that a fair statement?
Yes, Your Honor.
Okay, do I need to reach out to drug court to make sure they are trying to interview Mr. Miller?
I've been in touch with them and they seem on it about with regards to Mr. Miller.
Okay, but we'd like to get the acceptance before we take the plea.
Correct.
Okay. All right, I'll circle back with them as well. Mr. Miller, do you have any questions about what we talked about? No one's made any decisions yet, but it sounds like Ms. Patel is taking steps to get you referred to and accepted by our accountability court that focuses on folks who are working through addiction issues. Is that something you're open to?
Yes, sir. I am.
Okay. It sounds, Ms. Patel and I will both check up on that because that's something they need to be processing. You've been in jail now for over a month, it sounds like, and
Yes,
we need to get you into treatment
Yes,
and not have you sitting there if that's the right next step. Ms. Hall, you're aligned with a plea to drug court?
Yes, Your Honor.
Okay. Well, then the other thing we need to talk about today is whether Mr. Miller is wanting to be formally arraigned, meaning I read the indictment into the record, or Ms. Patel, if Mr. Miller is willing to waive arraignment, and then we'll do what we can to get the drug court process going.
I have no issues with waiving arraignment. If Mr. Miller requests a formal arraignment, that's up to him.
Okay. Mr. Miller, it is up to you in the end. Ms. Patel can give you her advice on this, and she's recommending you waive it. You don't give anything up by waiving it. It just means I don't read your indictment into the record and everyone hears what the charge is. But you're entitled to that if you would like me to read the indictment into the record and advise you of your rights to a lawyer and right to silence and whatnot. I'm happy to do that. What is your preference, Mr. Miller?
I defer to everyone's judgment to waive my arraignment.
Okay. Well, I hear you saying that you concur with Ms. Patel.
Yes.
Ms. Patel, if you would please file a waiver of arraignment, and I know that doubles as an entry of appearance. I think Odyssey is showing you as the lawyer anyway, but no, it doesn't. Let's see. Let me look here. No, there's no lawyer listed for Mr. Miller. So if you would do the waiver of arraignment and entry of appearance, that'll help tighten up the system. Our calendar has you listed here, but Odyssey doesn't. And then I will check with drug court. The referral has been done, so I need to figure out what their situation is. I would like to get Mr. Miller rolling with that. Assuming we get the green light from drug court, then Ms. Patel, I'll ask you to coordinate with Ms. Hall as to how quickly you two could be ready for a plea. And then we can see which calendar comes up next for us first. A virtual one, if Mr. Miller is willing to take the plea in this remote setting, or our next inmates come to court calendar. We could certainly take Mr. Miller's plea then. So,
Okay.
I was misunderstanding a little information I was getting from Ms. Nelson. She's not seeing a referral. I thought she said it had been completed, but that was a question. Has it been completed? So what's the situation with that, Ms. Patel?
It hasn't been completed because I was under the impression that normally we wait till they've interviewed him to do the referral. And I've already been in touch with Mr. Abrams, doesn't need it to do everything on his end, but I'm more than happy to fill it out. It was my understanding that we couldn't do the referral until he'd been interviewed.
Okay, let me find that out. I have heard both. One is that they really want the referral to go interview. And then I've also heard we might as well interview him first. Why waste your time on a referral if it's not going to work? There needs to be one answer to that.
Right.
And it sounds like it depends on who you ask. I will also get to you, Ms. Patel, and Mr. Franklin and Ms. Snyder, the new referral form that we've rolled out. You may already have it, but you'll get it again. But it supersedes and replaces the old one. I haven't had an opportunity to send it out to all my colleagues and all the litigation managers, but in the very near term, that'll be the new official one. And I have asked drug court and the accountability courts to actually politely reject the old form and require that the new form be used once we roll it out. It hasn't rolled out yet, but I'll get it to you all, and I'll get that official answer as to which comes first, interview or referral. That was a lot of talking, Mr. Miller, but it is all meant to figure out how soon we can see if you are the right fit for drug court and drug court is the right fit for you. Okay?
Thank you, sir.
Do you have any questions of me before we move on to our next case?
No, sir. I'm happy with the judgment.
Okay. Well, Mr. Miller, I look forward to seeing you again soon. If all goes well, it'll probably be for a plea. In this case, that will get you released to drug court.
Thank you, sir.
All right. Ms. Patel, anything else on behalf of Mr. Miller?
No, Your Honor.
Ms. Hall?
Nothing from the state, Your Honor.
Okay. Thank you both on that case.
Thank you all.
So next up is Earl Crosby. You do not need to take this one down. You, Mr. Crosby?
Yes, sir, I am.
Good morning, Mr. Crosby.
Good morning.
Mr. Crosby, I think you got picked up on a warrant in this case, or a warrant. We have a case from 2019. That's when you were indicted. The incident may be even older than that. But I also have a note here that you have new charges that are not yet indicted that I'm going to look up just while we're talking. Ms. Patel, tell me what you think we're going to be doing with Mr. Crosby today.
Just some background, Your Honor. This case was actually a track 1 drug court referral, and that referral was done August 21st of 2019. The issue was that Mr. Crosby was on first offender probation in Gwinnett. And so we were trying to get Gwinnett to agree to attach the program to his probation. Instead, they insisted on revoking him. And so he was taken to Gwinnett County. A warrant was supposed to attach while he was in Gwinnett to bring him back to Fulton, but that never happened.
Yeah, that's, yeah.
Right. And so he is back here after having addressed his probation in Gwinnett. The plan is still to move forward with the track 1 referral. With that being said, I did reach out to Mr. Abrams. He says that the interview doesn't have to be redone, but they have to rerun his medicals, and they just need to talk to him some more about his Gwinnett probation to make sure that we don't run into the same problem, given that he now has a new case. The goal would be, I don't have that file because it's a CP case, and I don't even know if it would come to this courtroom if this case ends up resolving as a track 1. But the goal would be perhaps to have that also be a referral or probation or whatever it is that's worked out. But this case, the referral has been filed. He was interviewed, accepted. The only issue was his Gwinnett County hold.
So I see, I thank you for that update. I see Mr. Crosby as being in a no bond status on his CP case. So that would interfere with things as well. In a few weeks ago, he had a bond hearing, and a magistrate whose last name is hard to pronounce denied bond. So this would need to be sorted out before drug court would be an option. And I think drug court would also need to evaluate the existence of the new charges. It sounds like Mr. Crosby was viewed as a good candidate, even though the charges in the indicted case, the one that we are working on, were alleged a crime of violence. There must have been enough facts and circumstances behind that he was able to disclose, or you were, Ms. Patel, or your predecessor, that drug court was okay saying yes to Mr. Crosby. This new case may raise other flags for them. The main flag would be Mr. Crosby doesn't have a bond. So
Right.
We need to work through that as well. The way it's charged, the new CP case, which obviously can't be indicted anytime soon, would it stay with you, Ms. Hall, or would it be a CWAC case? Do you know what I don't mean to hide it, it's cruelty in the first degree.
Yes, Your Honor, it'll be a CWAC case.
Okay. Did you have a chance to chat with CWAC to see what they intend to do with the case?
No, Your Honor. Right now, because it's in pre-indictment phase, I've just communicated with the attorney that has him on the CP number. Because right now I don't have a police report or anything that I can refer to. So I'm waiting to get information on that. And I'm not sure who in pre-indictment has been handling the CP case on the state side.
Okay. Well, it sounds like it is worth a conversation with drug court. The arrest citation for Mr. Crosby indicates that he was supposedly in a physical altercation with a child. And then it goes on to say that the accused conducted the assault under the influence of alcohol. So that may well be what the situation was with the family violence, the aggravated assault case as well. And Mr. Crosby, I'm not ignoring you. I know you're there. We don't need to get into the allegations of either case. This isn't the appropriate setting. I'm just trying to work through what's keeping you in jail and what we're going to do. So it sounds like, Ms. Patel, we need to, how recently did you speak with Mr. Abrams about Mr. Crosby?
This morning.
Okay. And did that discussion include the fact that there are these new charges?
I believe he is aware of the new charges, but we didn't discuss whether or not that would be an issue in terms of his referral. So I will follow up with him. The ideal goal would be to see if a all-purpose hearing judge would be willing to have him released on bond to the program while we work through the new case. But I understand that's going to take time, and the program needs time to get the rest of his medicals. So I think that might be something we can hopefully time at around the same time.
Okay. Well, why don't you do this, Ms. Patel? You reach out to Mr. Abrams and see what else they need and make sure that they are factoring in the new charges that are out there for which Mr. Crosby was arrested. And we'll see what drug court says. If the answer is we still are prepared to work with Mr. Crosby as a client, then we can try to coordinate with All Purpose. If drug court's willing to take him and the state's not opposed to having Mr. Crosby in drug court, then we can work through that. But there's that other actor there, and that would be the state,
Right.
and they need to weigh in on bond in the CP case. And if the fact that there are these new charges that involve allegations of violence that were allegedly fueled by or connected with substance abuse, the state may need to think through, is it a track 1 or a track 3? So there's probably another round of conversations that need to happen all around. And I'll plug in with accountability court as well. Ms. Hall, anything you want to add about Mr. Crosby?
No, Your Honor.
Okay. Ms. Patel, anything else?
No, Your Honor.
So Mr. Crosby, you will be hearing from Ms. Patel. You may be hearing from folks from the accountability court program as well. And as soon as we get a better sense of whether that's something that can work for you and that makes sense from my perspective and the prosecutor's perspective as well, we'll try to get that moving along. Do you have any questions, not about the facts of your case or anything like that, but just sort of procedurally where we are, Mr. Crosby?
No, sir.
Okay. Ms. Patel, I don't know that there has been I'm going to look it up right now, an arraignment for Mr. Crosby. I look at the events here. He was indicted. He got a bond. And then I guess because of all the things you described, then he went to Cobb and whatnot. There is no waiver of arraignment for him, although you are listed as his attorney. So just so that the docket reflects that everything that needs to happen has happened, do you mind filing a waiver of arraignment now that Mr. Crosby is back and we are focused on the 19 SC case again?
I do not. I'll file one today.
Okay, great. Mr. Crosby, how long were you in custody with Cobb County?
Gwinnett County, sir.
I'm sorry, Gwinnett County, yes.
For a month.
1 month?
Yes.
Okay, and then in theory, Ms. Patel, Mr. Crosby was supposed to come right back, but that old release to a hold and place a hold didn't work. Because
Right.
he was released by Gwinnett, and then everyone lost track of everyone.
Correct.
Okay, all right. Thank you. I need to ask the folks from the sheriff's office if we can go slightly out of order because one of our attorneys has to get to the doctor, but I think it will take care of South Annex. So if there was a way we could handle the 2 South Annex defendants. Am I correct, Ms. Snyder, that both your clients are at the South Annex?
Yes, sir.
These will be quick, but
Yes,
our
sir.
next defendant at Rice Street is going to be a longer hearing, and our attorney needs to see a doctor. So it would be great if we could do Ms. Tucker next.
Yes, sir. Good morning, Your Honor.
Good morning. Hello, Ms. Tucker.
Hello, hi.
So, Ms. Tucker, you got picked up on a failure to appear warrant a few weeks ago, and we need to figure out what we're going to be doing next with your case. And I should introduce myself. I'm Judge McBurney, and your case is assigned to me. It was originally with a different judge, but I have inherited that judge's docket. And we need to make sure we're moving your case along. So, Ms. Snyder, have you and Ms. Tucker had a chance to discuss what we're doing today?
We have. Today we're going to waive arraignment. I filed a bond motion late last night after I spoke with Ms. Tucker, but I don't think it's hit Odyssey yet, but it should come up soon. So I'd like to be set down for that. This is a 2017 incident that was just indicted in the end of 2019.
Okay.
So
Well, if the bond motion has not yet hit the calendar, I mean, the docket, but we will certainly have a hearing on that motion. We'll want to make sure we give the state a chance to get anyone present for that hearing when we do it. And we can work with you, Ms. Snyder, as to whether it would be remotely like this, if it would be on one of our in-person calendars, or if Ms. Tucker is waiving her presence, and then it could happen. We don't need to wait for one of those two calendars in the rotation. But that's something you and Ms. Tucker should discuss. And then you can let Ms. Nelson know which her preference is and yours. And we'll get this case for purposes of bond on the next available calendar of whatever format you choose.
Thank you, sir.
And then you'll file the waiver of arraignment, and that will constitute the entry of appearance as well. The system is showing you as Ms. Tucker's lawyer, which is great, but we still need the waiver of arraignment. Ms. Tucker, that's about all we were going to do today on your case. Ms. Snyder has taken all the right steps to get your request for bond in front of me, and we'll hear it. We can't hear it today because the state needs to get notice of that, and they may want to have a witness present, and they're entitled to do that. But real soon, we'll reconvene to talk about bond. Do you have any questions about what's going on with your case that I can help with?
Because I don't have money, I was trying to see if I was going to be eligible for a plea.
Well,
I'm sorry, Miss Snyder.
that's okay.
What was you about to say?
Just, this isn't the time for that. Like I said, like I told you last night, I'm talking to the state, and we'll get there.
Okay.
So, Ms. Tucker, you and Ms. Snyder will keep talking about this. She's real good at keeping in touch with her clients. But today, we needed to meet and take care of a couple formalities like arraigning you or waiving that arraignment, which is what's happening. And then Ms. Snyder was able to share with me that she intends to have a bond hearing for you. And we'll do that. It may be that the bond hearing is the time to work your case out. I have no idea. I'm here to handle what the lawyers have prepared.
Okay.
But Ms. Hall, who you can see on the screen as well as the prosecutor, she'll be handling the bond hearing. And if it's going to be a plea someday, she'll be handling the plea on behalf of the state. And then Ms. Snyder, of course, will be your lawyer, and she will be with you every step of the way. Okay?
Okay.
Ms. Hall, anything on Ms. Tucker's case?
Nothing from the state, Your Honor.
All right, Ms. Snyder, anything else for Ms. Tucker?
No, Your Honor.
All right, so you'll let Ms. Nelson know about which of the formats you want for the bond hearing, and we'll make it happen.
Thank you, sir.
All right, see you soon, Ms. Tucker.
Okay.
Then we have Ms. Bette Sill. And there she is. Hello, is it pronounced Bette Sill?
Yes, sir, it is.
All right, good morning, Ms. Bette Sill. I'm Judge McBurney. It's nice to meet you remotely.
Good morning.
You are here on a burglary charge, and you have already been on a few calendars, and we need to figure out where your case is heading. I'm going to ask Ms. Snyder, your lawyer, to give me her thoughts about that. I'll also hear from the prosecutor, Ms. Hall, who's on this call. I'm looking at your case. It looks like there are 3 defendants. One, Mr. Mitchell's already resolved the case. Ms. Patel has Mr. Turner, but we can't find Mr. Turner. And then we have you, and we found you. And so now we need to know what we're going to do next. I think your case had reached what we call the final plea stage, but that was on a day when we wouldn't have had court because of the pandemic that has befallen us. So
Yes, sir.
Tell me what's going on, Ms. Snyder.
Your Honor, Ms. Bette Sill has been on bond this whole time. It is a 3 co-defendant case. One of the issues and why there are so many different court dates was Mr. Mitchell was in prison. And DAs tend to not, they want to do co-defendant cases together. So it kind of lingered till we got Mr. Mitchell in, and then he subsequently pleaded guilty and then made a statement. I have provided that statement to Ms. Hall. We've been pre-trying. So I'm really just waiting for an announcement from Ms. Hall.
Well, why don't we turn to Ms. Hall? Hello, Ms. Hall.
Hi. So I'm not quite there yet. I have not been able to fully get all the information from this case and talk to Ms. McCauley about it. So maybe that'll happen next week, but I'm not there yet.
Okay, well then it sounds like Ms. Snyder, if we need to have a bond hearing for Ms. Bette Sill, you ought to file something, and there's no need for you or Ms. Bette Sill to wait on Ms. Hall to do what I know she's trying to do. I know how that process works, and she's in that long line to get with Ms. McCauley. But if in the meantime we need to talk about bond, then we can do that. It may be that you're doing a balancing act, Ms. Snyder, and you're simply thinking there may be a resolution that won't require a bond hearing, but you need to hear those magic words from Ms. Hall, and I understand she needs to perform some due diligence. What's your best guess, Ms. Hall, as to when you might have an answer?
Next week. Ms. McCauley has been on vacation this week, so we didn't connect like we were supposed to yesterday, but I'm sure middle of next week I should have an answer. Okay. And is it your understanding that you might get an answer that wouldn't require us to connect in this way, get Ms. Bette Sill on a Zoom call? And I'm asking only because, you know, we don't get these calendars every day. So you may learn on Wednesday what you need to learn from Ms. McCauley. You relay it to Ms. Snyder. Do we need to wait to our next Zoom session to work through it, or it depends on what the answer is? I honestly don't think the answer is going to be what Ms. Snyder was looking for. So I believe that we don't have to wait. I think that me and her can continue to negotiate the case, and we can go ahead and set it up, and by then I will have an answer. I know now that it won't be what she was originally looking for, but maybe maybe something close to it. Okay, I just looked at Mr. Mitchell's plea again in front of another judge, and it's a different defendant, but he got 5-1 community time served, balance suspended, so he's done. That's at least a marker as to how your predecessor, was it your predecessor, Ms. Hall, who sorted that out, or was that part of your great clearing effort? Well, no, it wasn't my predecessor. It was someone that was covering for me, but I had never seen the case. So then they handled the case without me. So okay, it was someone that may not be reflective of your view as to what should happen in the case. Right. Got it. Okay. And certainly you're not bound. It's another defendant. So Ms. Snyder, you've got the update. I've got the update. Let Ms. Nelson know if there is a reason other than to resolve the case to get Ms. Bette Sill back online like this or into court, and we will certainly process the case as quickly as we can.
Given Ms. Hall's announcement, I will file a bond motion today.
Okay, so Ms. Bette Sill, when we get that bond motion, we'll figure out which calendar to put it on, either one like this where you are appearing remotely, or one where you can be in court, or it may be you and Ms. Snyder discuss it and you're comfortable not being present for the bond hearing, and then we'll do it via Zoom like this. We just don't have to patch you in from the jail. That's a decision for you and Ms. Snyder. She'll be in touch with you, but we will have that bond hearing soon. And it may be we resolve your case soon, but it sounds like the prosecutor and your lawyer will keep talking. Any questions, Ms. Bette Sill?
I just maybe for my attorney to find out like how soon would it be?
Well, you two can talk about that. She'll file the motion today, and she doesn't control when it's heard. That'll be something that I work on with my staff as to how quickly we can hear your bond hearing. But it's something that we would do in the next few days. It's not months.
Okay.
So we would reconnect soon. Okay.
Yes, sir. Thank you.
All right. Thank you, everyone.
Thank you, Judge. And that completes my business. May I be excused?
Yes, ma'am.
Thank you. You guys have a good weekend.
You too. Thank you, South Annex.
You're welcome.
All right. We turn now to position 3, and thank you again, Rice Street, for allowing us to pivot to South Annex. We have Gregory Watson now. Is that you, Mr. Watson?
Yes, Your Honor.
All right. I have on my calendar, this is going to be a plea, but I'm going to hear from your lawyer, Mr. Franklin, who you can see on the screen there, to see if that is still the game plan. Good morning, Mr. Franklin.
Good morning, Your Honor. That is still the game plan. We have a negotiated agreement.
All right, and I think I've got the case file, so I'll be able to sign the indictment for everyone. Let's get started. Are you ready, Mr. Forte? All right, so position 3 is State versus Gregory Watson. It is indictment 20 SC 175614. Mr. Watson, in the indictment, you are charged with aggravated assault and aggravated battery. Ms. Hall, is this a plea to those charges, or are there reductions? What's happening?
Your Honor, partially, the state will be reducing the second count, aggravated battery, to battery. And Ms. Nelson, if you give me one moment, I'll give you the code section.
I can look that up. We'll keep going because you'll be talking a whole bunch, and while you're talking, I'll get her the code section. So it's a plea to count 1 felony and then count 2 misdemeanor.
Yes.
Okay, and Mr. Franklin, that's your understanding?
Yes, sir.
All right. So Mr. Watson, the way we're going to do this is that in just a moment, Ms. Hall is going to ask you to raise your right hand. She will put you under oath. Once you're under oath, it's important that you answer all of her questions truthfully and completely, and that you answer my questions as well. I'm going to have a few after Ms. Hall is done talking with you. It is just as important that you let us know if you have questions of your own. I need to be comfortable at the end of our conversation that you understood what we were talking about. So if at any time someone says something that's confusing or is different from what you were expecting, I need you to pipe up. Will you do that?
Yes, sir.
All right. I need to cover 2 things with you before Ms. Hall swears you in. In normal times, Mr. Watson, you'd be here in court in front of me. We'd be able to see each other more directly, et cetera. But you are at the jail right now. I need to make sure you are voluntarily waiving your presence here in court and that you're willing to proceed with your plea remotely from the jail.
Yes, Your Honor.
The other important right that we are tweaking a little bit today is that your lawyer, Mr. Franklin, is not by your side. Normally, he'd be here in court with you, and you two could readily confer, talk, ask questions of each other, et cetera, if something came up during the proceedings. But Mr. Franklin is on the screen, just like you are and I am, and it is more complicated for you to have a private conversation with him. We can make that happen if you need to, and you should let me know if you want to. But otherwise, Mr. Franklin will be virtually present, but not physically present. Do you waive your right to have Mr. Franklin by your side during this plea?
Yes, Your Honor.
Okay. With those waivers, Ms. Hall?
Thank you. Mr. Watson, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
Gregory Lamont Watson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
28, 9th grade.
Are you able to read, write?
Hold on, I'm sorry, pause for a second. 28, and what grade did you complete, Mr. Watson?
9th grade.
9th grade, thank you.
You're welcome. Do you understand that you've been charged with the following offenses? Aggravated assault and aggravated battery being reduced to battery?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
I do want to ask him a question if it's possible.
Okay. Do you want to do that right now or
Yes, sir.
at a different point?
I want to do it
Pardon
right
me?
now. If it's
Okay.
right now, if possible.
All right, so let me ask the folks who are there with you, if I move, meaning the deputies, if I move courtroom 2 into a chat room with Mr. Franklin, does that work for the deputies?
Yes, sir.
Great, I will do that. So Mr. Watson, in a moment, one of the deputies is gonna have to press some button on the computer. You and Mr. Franklin are gonna move into a chat room. It's private. I cannot hear or see what's going on. No one else you see right now can. Obviously, if there's a deputy standing next to you, he's gonna hear what's going on. But you and Mr. Franklin are having a private conversation away from us. Does that make sense?
Yes, sir.
Okay, and that's what you'd like to do right now?
Yes, Your Honor.
All right, let me see if I can make it happen. All right, should go. Good luck. Come back to us when you're done. Ms. Hall, probation didn't join us on this call. Hopefully probation will. We'll work through why this keeps happening. Is the criminal history for Mr. Watson going to be a source of controversy, or do you think that everyone agrees?
I think everyone agrees.
Okay, great. Hello, Ms. Hodge.
Good morning, Your Honor. While we're waiting, will probation be joining us because Timothy?
They better. Ms. Nelson is reaching out. I just
Okay.
noticed because we were starting a plea and I made my little note, what's criminal history? And I didn't see anyone on the call.
Okay. I'll wait. Thank you.
Sure. That's okay. It's like, what happened? You fixed it. Oh, and I need to make that note to find out who's coming in the courtroom. Wow, this must have been one of the last indictments. Late February.
We're back.
Great. Give me 1 second. All right. There he is. Mr. Watson, we're going to go back on the record now. Did you have enough time to speak with Mr. Franklin?
Yes, Your Honor.
Are you prepared to go forward now?
Yes, Your Honor.
All right, Mr. Franklin, were you able to interact meaningfully with Mr. Watson during the breakout room?
Yes, sir, Your Honor.
Great. All right. Back to you, Ms. Hall.
Thank you. Mr. Watson, I'm just going to ask you again, do you need any more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, if any, for purposes of this plea.
Mr. Watson, have you been arrested on these charges?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
We are not aware of any outstanding warrants.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum and maximum for aggravated assault is 1 to 20 years to serve, and the maximum for battery is 12 months to serve. Do you understand that this is do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for aggravated assault, 5 years probation, for battery, 10 months to serve, to run consecutive to count 1, but the court does not have to accept that recommendation. The court can sentence you to the maximum on both of those charges.
Hold on a sec.
Yeah,
I'm confused by the sentence. It was 5 years probation on the felony and then 10 months to serve consecutive for the misdemeanor.
It was read backwards. It should have
So
been.
the misdemeanor would come first, serve the 10 months followed by 5 years probation.
Correct.
Okay.
Yes. Sorry.
Got it.
Mr. Watson, do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each of these charges and can run them consecutively or one after another.
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Okay. Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 20-SC175614, how do you plead to the charges of aggravated assault and battery?
Guilty, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is aware of one prior felony conviction by this defendant. It is a conviction out of Maryland, a armed carjacking. The disposition date was November the 5th, 2010. And had this case proceeded to trial, the state would have proven that on February the 27th, 2020, at 275 Pryor Street, Atlanta, Georgia, in Fulton County, officers were dispatched to that location in reference to a stabbing. The defendant had gotten into a disagreement with the victim. And during that disagreement, the defendant pulled out a knife and stabbed the victim twice, one in the shoulder and one in the shoulder area and one in closer to the front shoulder area of the victim's body. The victim did sustain those injuries. He was checked out by Grady. He is ultimately okay. He has healed from those wounds. The defendant and the victim knew each other from staying at the Gateway House. They were both in a program at this time when this happened. The defendant had been released from the program, or I'm not sure, Mr. Franklin no more, but he was no longer a part of the program living at that place, but that's how they knew each other. So officers were able to quickly identify who the defendant was. The victim picked him out from one of the photos from the Gateway House, and arrest warrants were taken out. The defendant was picked up and charged accordingly. That is all from the state.
Okay. And does Mr. Taylor have a perspective on the appropriate sentence? Have you had any luck getting in touch with him?
Yes, I've had a couple conversations with him, and he doesn't have an issue. I've discussed our recommendation with him, and he doesn't have an issue with our recommendation. He actually says that he was more of a mentor to the defendant, and he was trying to advise him to get on the right path as he's been doing. You know, he's been working, and he doesn't want to see him punished, as in go to jail for multiple years for this incident. He felt like it was just a misunderstanding or a disagreement that went too far. So he's on the same page with the state as far as the state is a little bit higher than what he recommended, but we feel that that is appropriate due to the injuries. Okay.
So he's fine, has full use of his arm, et cetera.
Yes, Your Honor.
Okay. I don't think you said, I may have missed it, a no contact provision, but it seems like Mr. Watson and Mr. Taylor probably shouldn't spend a lot of time together, or does Mr. Taylor have a different view of that?
Well, I asked him, he didn't say he had an issue with being around Mr. Watson, but apparently they haven't been around each other since this incident. He was still living at the Gateway. The victim, Mr. Taylor, was still living at Gateway and continued on with his life. And he hasn't had any conversations or any further disagreements or anything with the defendant. I mean, he did get picked up shortly after, but you know, he just said that he's not worried, he's not concerned or scared for his life.
Okay. All right. Appreciate that. Hello, Ms. Crawford.
Good morning, Judge.
Good morning. Do you have any Georgia criminal history for Mr. Watson?
No record found for Mr. Watson.
Okay. Ms. Nelson tells me you weren't necessarily aware of today's calendar. Our next event is probation revocation. So hopefully you're going to be in a position to provide some info on that one. Not right now, but it's what's up next.
Yes, sir.
Okay. Mr. Franklin.
Thank you, Judge. We ask that you accept the plea as negotiated. I never had the opportunity to speak with the complaining witness, the victim in the case. And I think just because of COVID and his status of living in a shelter, just wasn't able to get any one-on-one contact with him. However, I have been in consistent contact with Mr. Watson's fiance. She and some other people have reported to me that they've come across the gentleman, Mr. Taylor, and that he pretty much said the same thing that Ms. Hall is relaying to the court, that he wasn't seeking to over prosecute or, you know, throw him under the jail or anything like that. From our position, Your Honor, understand that the jail does give 2 for 1 time on misdemeanors. Mr. Watson does still have about 2 months left under that calculus. He was brought into custody either March 1st or March 2nd. The booking screen says March 2nd, but I think he may have actually gotten in March 1st, which would mean that he would at least be in custody until August 2nd. The injuries were not severe, and Mr. Watson apologizes for his actions that day.
What is Gateway?
It's a homeless shelter. It's on Pryor Street, right once you get to Memorial Drive. So on the other side of the Memorial Drive from the highway.
Okay.
So if you come out the front of the court, if you come out the stairs on the courthouse, just turn left and go down.
It's right there.
Yeah.
Okay. And at one point, Mr. Watson had been staying there, but he no longer was. But that's how he knew Mr. Taylor, or what's your understanding of the connection?
That is correct. They both lived there at some point in time, but during this particular date, my belief, correct me if I'm wrong, Mr. Watson had been living with his fiance by this point. He wasn't residing at Gateway at that time.
Okay. So, Mr. Watson, how long had you been staying at Gateway?
Probably for like a month.
Is that where you met Mr. Taylor, or did you know him from before?
That's where I met him.
Okay. You have a fiance. Is that where you would go live when you get out?
Yes, sir.
And where does she stay?
What's this, Auburn Avenue? I think Auburn Avenue.
She has an apartment?
Ashburton.
Oh, Ashburton.
Ashburton Avenue, Decatur, Georgia, 30033.
Okay. So you'd be over in DeKalb County?
Yes, sir.
Okay. Do you know who else lives in the house with your fiance right now?
No, sir.
Okay. When did you come to Atlanta from Maryland?
January 1st, sir.
Of 2020?
Yes, sir.
How long did you serve for the carjacking case?
I did 7 years flat.
When did you get out?
2015, and I got a 20-year suspended with 7-year sentence, and I completed my parole and probation.
Okay, and all that was up in Maryland?
Yes, sir.
Okay, what brought you to Atlanta?
New start.
New start, okay. What were you and Mr. Taylor arguing about on February 27th?
Some money, sir.
Okay, and what did you stab him with?
Knife, sir.
Okay. Was it like a kitchen knife or a pocket knife, or where did it come from?
It was a pocket knife.
All right, just something you were carrying?
Yes, sir.
All right. Anything else?
No, Your Honor.
Would you have any reason to be around Gateway when you get out?
No, sir.
Did you manage to get any work after you came down to Atlanta this year?
Yes, sir. Actually, when I got inside the program, I got 2 jobs. I was working at Fort Dustry at the Colgate Center.
Mhm.
Then I was also working at Georgia World Congress Center downtown. So I
Okay.
managed to get 2 jobs.
Great. Well, that's promising. I hope you're able to get back involved with something like that. It just will need to not be through Gateway. I guess you'll need to find a different program.
Yes, sir.
Okay. All right. Well, Mr. Watson, I find there's a factual basis for your plea. You and Mr. Taylor were having a dispute about money, and you took it to a place it didn't need to go and shouldn't go again. I'm glad Mr. Taylor is okay, and that he's a forgiving type of person. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we talked about. And if you didn't, you asked for a chance to speak with Mr. Franklin, which you got. Is that a fair statement?
Yes, sir.
Anything you need to talk to Mr. Franklin about right now off in the little break room?
No, sir.
All right. A voluntary plea is simply a plea that you're making of your own free will. No one's forcing you to enter this plea, but you've decided that it's the right way forward for you. Is that a correct statement?
Yes, sir.
Okay. Then I'm going to accept your plea, Mr. Watson, to count 1 as charged and count 2 as reduced. I'm sentencing you pursuant to the Probation Options Management Act, which is a long term for something that means simply that while you're on probation, if you have a technical issue, you miss a meeting, or, and I'm just making this up, if you tested positive for marijuana or something, you don't have to come see me. You'll work with probation, and they may have some things they need you to do, and you'll do those things. The only reason why you'd be coming back in front of me while you're on probation is if you are arrested on new charges. So if you're staying out of trouble, you're working, you're taking care of your fiance, you and probation will be managing everything. Okay?
Yes, sir.
So I'm going to sentence you, Mr. Watson, as follows, and listen up, because it's a little different from what was negotiated, and you have the ability to withdraw your plea if you want to, because the sentence is going to be not exactly what you negotiated. And I'll give you a chance to talk with Mr. Franklin, and if you want to say no thanks, you'll be able to say no thanks, and we'll just keep moving your case along. On count 1, I'm going to sentence you to 6 years to serve 11 months with the balance probated. And you'll get credit for all the time you've been in. Because it's a sentence of less than a year, you will likely stay right where you are, and you will likely continue to get 2 for 1. I think a year is an appropriate sentence for someone who stabbed someone else twice. But I appreciate, and I know what I would hear from Mr. Franklin. If I gave you a year, that becomes structurally a very different sentence, and you may have to be sent to DOC, Department of Corrections, and who knows what. And I'm going to respect the negotiations that went on and the perspective of Mr. Taylor. And so I'm keeping it under a year, but you will get credit for all the time you've been in. And your probation will be 5 years and 1 month rather than just 5 years. But rather than stacking the sentences, I think this is a cleaner way to do it. Your sentence on count 2, the misdemeanor, will be 11 months to serve. It will run concurrently, meaning at the same time with count 1. And there'll be a few special conditions of your probation. One is that you have no contact with Mr. Taylor. Stay away from him. You don't try to reach out to him. And 2 will be you stay away from the Gateway Center. All right? I'm going to waive your probation supervision fee for the first 3 months. When you get out, you're going to need a minute to get situated, and hopefully you'll get working. And I will tell you that if you are not working at least part-time, meaning at least 20 hours a week, by the end of those 3 months, then if at the end of the 3 months you are unemployed, then you're going to need to do 10 hours of community service for each week you're not working at least 10 hours. Does that make sense?
Sure.
Okay. Ms. Hall, did you have any other conditions that you wanted to see in Mr. Watson's case?
No, Your Honor.
Mr. Franklin, I'm going to give you a chance to speak with Mr. Watson, but did you have any questions or amendments to the sentence?
Yes. So regarding the sentence as it relates to portion one, charge one, part of what Your Honor stated was that you believe that he will still be able to receive 2 for one time as to count one.
Yeah.
And with it being a felony, I don't believe that that is correct.
Okay.
So I didn't know how much that portion, if you were trying just to mirror the terms or if you were actually trying to do something else.
So no, I don't get in the middle of the 2 for 1 piece. What I was trying to do was keep the sentence such that Mr. Watson would stay at Rice Street. And I thought if it was under 12 months, then he would stay at Rice Street. I'm not disagreeing with you as to whether it's 2 for 1 or not, and I'll restructure the sentence. I'm sort of indifferent on that front, given what Ms. Hall has told me the state's perspective is and Mr. Taylor's perspective.
Yes, sir.
So if you believe that it would be a different scenario for Mr. Watson if it was 11 months to serve on count 2, followed by 5 years probation on count 1, I'm fine doing that. I'm neutral on that. Is that your preference?
Yes, sir.
Okay. I mean, it shaves a month off of probation, and based on your experience, it may make Mr. Watson more likely to receive 2 for 1 credit.
Thank you.
Okay. So, Ms. Nelson, I apologize if you've already started working hard on the final disposition. Mr. Watson, I don't think I'm changing a whole lot. She says, yes, she'd already started. But your sentence is still going to be 11 months, not 10. I'm going to give you a chance to talk to Mr. Franklin about that, because that's more than you bargained for, and you have the right to say no. So it'll be 11 months to serve on your misdemeanor, the battery count. And it will be 5 years probation to follow that. So when you're released, that will be the end of count 2 and the start of your 5 years probation. You'll need to report to probation, and you're actually going to be moved to a breakout room, whether you need to talk to Mr. Franklin or not, because I need you to speak with Ms. Crawford, who you can see on the screen there. She is with probation. She will not be your probation officer, but she's going to give you the reporting instructions so that when you get out, you go to the right place to get started with probation. And before you get concerned, you'll have to start in Fulton County. If your residence is in DeKalb, DeKalb will supervise you. But when you first report to say, hey, I'm Mr. Watson, that will be here in Fulton County. Okay?
Sure.
All right. Do you need to speak with Mr. Franklin about this, or are you comfortable going forward?
Can I speak to Mr. Franklin?
Yeah. So I'll move you two into the breakout room, and then you'll go into a breakout room one more time with Ms. Crawford so she can talk to you about probation. Okay?
Sure.
All right. Stand by.
Judge, I have a question.
Yes, ma'am.
Did you want him to be able to work at least 10 hours? Otherwise, he would have to serve, give 10 hours of community service. Usually you say 20 hours.
I did.
20 hours.
Correct.
You changed it.
I did. You listened, you heard correctly, and I spoke intentionally. It dawned on me that for some folks, it's not the easiest time to find work. And so if Mr. Watson isn't able to find 20 hours a week, but he's at least working 10 hours a week that he can document, then he doesn't need to do the community service.
Okay, thank you.
You're welcome.
And Your Honor, may I be excused? I don't have
Sure, you don't have Mr. Fox's case?
the calendar.
Pardon me?
I'm sorry, my internet went out. May I be excused? I don't have any other matters on the calendar.
Yeah, I didn't mean to keep you on. I figured you were still on because you had Mr. Fox's case. You are free to go. I don't know if you're on this afternoon's calendar. If you're not, have a great weekend. If you are, I'll see you this afternoon.
I am on for this afternoon, so I will see you then.
Okay.
All right. Thank you.
Bye.
Bye-bye.
We are on a break still. Mr. Forte needed to take a break, so we need to wait for him to come back so we can get on the record.
Yes, sir.
Okay, you good? Yes. All right, we're back on the record in the matter of State versus Gregory Watson. Mr. Franklin, did you and Mr. Watson have a chance to discuss Mr. Watson's preference in terms of moving forward with the plea or withdrawing the plea?
Yes, sir. We did have the opportunity to have that discussion.
And does Mr. Watson want to move forward?
Yes, sir, he does.
Okay, Mr. Watson, do you have any questions of me about the sentence?
No, sir.
Okay, one last thing I need to do, and then I'll see if there's anything else from Ms. Hall or Mr. Franklin. I'm holding your indictment right here. I don't expect you to be able to read it, but if you were here in court, you would have today signed the indictment to indicate that you're entering a guilty plea. Do I have your permission, Mr. Watson, to sign your name on the indictment?
Yes, sir.
Mr. Franklin would sign it as well as evidence that your lawyer was aware you were entering a guilty plea. Mr. Franklin, may I sign on your behalf?
Yes, sir.
And finally, Ms. Hall would sign it to indicate that the state was going along with the guilty plea also. Ms. Hall, may I sign on your behalf?
Yes, Your Honor.
I will do that. Ms. Hall, anything else in Mr. Watson's case?
Nothing from the state.
Mr. Franklin?
Nothing further, Your Honor.
Mr. Watson, I wish you luck. Hopefully your restart of your new start here in Georgia goes better. You'll stay away from Gateway. More importantly, you'll stay away from Mr. Taylor. But I hope you find work and that you and your fiance have a good situation going when you get out, okay?
Sir.
All right.
All right, take care, Greg.
So I need to move you and Mr. Franklin and Ms. Crawford into a breakout room. Ms. Crawford will give you the basics on probation, and then we'll be good to go. And then Mr. Franklin, are you handling the Fox case?
Yes, sir.
Okay, so you and Ms. Crawford will come back in, and that'll be it for Mr. Watson. Let me move you all to this breakout room.
Nothing.
Okay, this should work.
Your Honor, give me a second to clear out the courtroom for this next position.
No problem. Just let me know when you're ready.
Okay.
Good morning.
Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Are you on this afternoon?
I'm not.
Well, have a great weekend.
You too. Bye,
Bye-bye.
everyone.
Later.
All right, the courtroom is clear, Your Honor.
Thank you. Okay, this is Z89781, State versus Timothy Fox. And it is a probation revocation matter. Ms. Nelson, I don't have the petition. I had it when I think we were going to handle Mr. Fox's case in the past. I'm looking in, I may be able to find it in Odyssey. Just give me a second. But
I'll look as well.
okay. I have an addendum. Let me see if there is also. So there was apparently a petition for revocation that was dated in January of this year that alleged a violation. I don't have my hands on that. I have an addendum that was filed then in March that brings additional alleged violations. I want to make sure we make a record of what the allegations are, and Ms. Nelson can hopefully keep digging for that. But Mr. Fox, first let me introduce myself. I'm Judge McBurney. I don't think we've met before. I certainly did not originally have your case. I was working in the DA's office back when they had Z indictments, I think. At least I've seen them before, but it's an old case. Mr. Franklin is your lawyer for purposes of this revocation proceeding, and Ms. Hodge, who you can see on the screen, is the prosecutor for the state. I don't think either of those lawyers would know a whole lot about your underlying charges. Those were resolved long ago, and we're really not focused on those so much as what's been going on or what has not been happening more recently in the sense there were conditions to your probation, and if those conditions were being violated or weren't being met, then we need to work through if there ought to be consequences for that. You've been in jail for a while now on this warrant, and we need to see if we're able to get closure for it. Mr. Franklin, have you and Ms. Hodge had a chance to talk about whether this is something that is resolvable by way of not contesting the allegations, or do we need to get into the substance of what the allegations are?
It can be resolved, Your Honor.
Okay. Well, why don't you start then and let me know what's been going on with Mr. Fox and what you think ought to happen. And then I will hear from Ms. Hodge. And of course, Mr. Fox, I'll hear from you as well. It's your case. I'll give you a chance to share with me your thoughts.
All right, so in the period of time that Mr. Fox has been on probation, believe the only issues he's ever had were a few times where he tested positive for controlled substances. He had no issues with attending his sex offender treatment courses or anything until he lost his job last year and money issues created a set of circumstances that led to him not being able to go to sex offender treatment. He's been in custody, I think it's 138 days at this point in time. And in light of his good record of reporting and remaining consistent in his requirements on probation, with discussions with Ms. Hodge, we came to an agreement amongst ourselves to continue Mr. Fox on probation. I discussed that with Mr. Fox a few weeks ago at this point in time, and he can give you more information about the role that drugs played in certain things if you have any more questions about that.
Okay, well, I will hear from Mr. Fox in just a moment. Ms. Crawford, how much, if you have it, what was Mr. Fox's original sentence? It doesn't appear in Odyssey because the final disposition was in 1997. And so I don't know what his sentence was, and more relevant to what we're working through here, how much time remains on his probation?
I can tell you how much time he has remaining while I look for the original sentence. He has 36 years, 3 months, and 5 days remaining on probation. And I'm going to look for the original sentence.
All right, this can be a big number, whatever it is, if there are 36 years remaining on probation. Okay, thank you for sharing that. Mr. Fox, what was the job you were working at that went away?
I worked for Ansley Atlanta Development Corporation.
Which is what?
It's a development corporation. I remodel houses, usually in the bluff or in rundown areas of the city of Atlanta, so that they can rehabilitate them and sell them.
Is this Ansley Atlanta the realtor group? Is it an arm of that, or it's something different?
It's all the Ansley family, but it's the real estate group. I'm in the construction division.
How long had you been working there before you lost your job?
For 4 years.
What happened to your job?
What had happened, sir, is that I broke my foot and I was unable to work. And the real estate agent that I was working for, Chris Amaro, she went to work for another company, and I kind of went with her. And they told me when I get out of jail, I can go back and apply to work for another real estate agent, but I have to come back to the office and resubmit an application like brand new again.
Okay. What real estate group did Ms. Morrow go to?
Oh, I don't know, sir.
Oh, I thought you said you went with her when she went to another agency.
No, sir.
Oh, okay. So you would go back to Ansley Atlanta in an effort to get back into the home rehab business.
There, or I would go to Israel Cohen, who owns another company called Shalom that remodels apartment buildings in Atlanta. I wanted one or the other. I could go to either. Israel Cohen is who I think I would go to. He offers more promise.
Okay. How did you break your foot?
A 2x8 fell on it.
Ouch. Okay. So when you lost your job, you had no income, and apparently you have to pay for the sessions at the Behavioral Medical Institute of Atlanta?
Yes.
How much do they cost?
$40 a session.
How many sessions do you have to go to monthly?
3.
Okay. And where is that in Atlanta?
It's at the Lenox exit of MARTA in Buckhead. It's right at the exit.
All right. When's the last time? I guess you've been locked up, so you haven't been to one of those sessions in a while.
No, it's been a while. Miss Crawford or somebody from probation would have to call them and ask them if when I can come back. It's when you get discharged or terminated, they don't take you back until they speak to probation.
Okay. Has this happened to you before?
No, I just have heard of it happening to many other people.
All right. Do you have housing?
Yes, I do now.
When you say now, what do you mean? You've been in jail for a few months. Why do you say?
Well, Israel Cohen has offered to let me stay in one of his apartments and work off the rent.
How do you know Mr. Cohen?
I worked for him after I broke my foot when I was getting better. he asked me if I do some leg work for him, running around and stuff. You know, I could get around. I just couldn't bear a lot of weight on it. And we became friends, and he just likes me.
Okay. So he'd help you with housing, and then in theory, you could do rehab work for him, if not for Ansley Atlanta.
Yes, sir.
All right. Mr. Franklin mentioned something about drugs. What did you want to share with me about that?
I take a lot of medication, antipsychotic medication. I'm schizophrenic, and I ran out of medication before when I got my violations, but I've made arrangements with the Momentum Group at Grady Hospital to have a psychiatrist appointment the day I'm released.
I'm not familiar with the Momentum Group. Is that like ACT? What?
It's outpatient at 10 Park Place.
Okay.
Right up the street from the courthouse.
No, I know 10 Park Place. I just didn't realize that one of the names for it was Momentum.
Yes.
Okay. Ms. Crawford, are you able to tell from your system whether Mr. Fox was working with a probation officer who specializes in mental health issues, or was Mr. Fox working with a probation officer who specializes in sex offenders, or do we have someone who does both?
It looks like he was assigned to a sex offender officer. That's the only thing that I can see. And he was reporting and he was doing what he was supposed to until he got the violation. But I can't tell if he was working with the mental health. But the officer that he was assigned to is a sex offender officer.
Okay. And when you say he got the violation, the one piece I'm missing is whatever was alleged in the first petition, which was dated January 8th of this year. I've got the addendum, but not because Mr. Fox did something with his ankle monitor. But do you know from your system what the initial allegations were?
I don't see the initial allegations. I also have the warrant addendum, and I saw where they said he was supposed to go to revocation court back in March with another judge, but I don't see any paper trail.
Okay. Mr. Franklin, you know what the original allegations were?
Sorry. No, I was only able to grab the things off of the Odyssey booking screen.
All right. Ms. Hodge, did you raise your hand because you could not hear Mr. Franklin, or you know what the original allegations are?
No, because I could not hear from Mr. Franklin. I don't have the original allegations either. I only have the addendum.
All right.
And
are we worried that the original allegation could be, I'm making this up, Mr. Fox, but Mr. Fox chopped someone's head off? I mean, if we're talking about putting Mr. Fox back on probation, having served some time, so there's a sanction for it, should we not make sure that the original allegation, alleged violation of probation from January of 2020?
I can tell you what they are if you'd like me to.
Yeah, sure. What
Sure,
what was probation?
I got a dirty urine. I had a dirty urine for marijuana. I didn't go to group. That's the group that I was terminated from. We were just speaking about. And I didn't report because after I had the dirty urine, the probation officer told me to come the next day, and I was afraid to go because I wasn't taking my medicine because I ran out of medicine, and I didn't go. Those are the allegations.
Okay. What happened with the ankle monitor?
I had that in the jail here for a month, and I was climbing out of the bed, and it got hung up on the bed, and the band popped off. I gave it to the officer, and the officer, he put it somewhere. I don't know where he put it. When the probation officer came here to get it, they couldn't find it.
Why were you wearing an ankle monitor?
It's part of my special conditions of probation for sex offender.
Oh, so you've been wearing one for a long time.
I've been wearing it for 6 years, and I've never had a problem with the leg monitor in 6 years.
Okay. So I assume, Ms. Crawford, a new one will go on to Mr. Fox?
Yes, he's going to have to report for them to put a new one on him.
Okay. Do you know where you report, Mr. Fox?
Yes, sir. Right behind the Gateway Center, by pre-trial.
I was going to say, we've just been talking about the Gateway Center, so
Yeah.
you know where that is. Okay. All right. So, Mr. Franklin, your recommendation is that there be a revocation that basically consists of time served, and then Mr. Fox be reinstated on probation?
That is correct, Your Honor.
Okay. Ms. Hodge, what's the state's view?
That's what we discussed a few days or a couple of weeks ago, Your Honor. And the recommendation was to continue him on probation. I also spoke with Ms. Crawford, who reached out to, I believe, the original probation officer, or she attempted to. I don't know if she got a response, but I did inform probation that that would be my recommendation. And there was no opposition to him continuing on probation. You asked about his original sentence earlier, Your Honor. And for counts 1, 2, 3, 4, and 5, he was sentenced to 20 years to serve 13, balance of 7 on probation. Counts 6, 7, and 8, he was sentenced to 20 years probation to run consecutive to counts 1, 2, 3, 4, and 5. And then for counts 9, 10, and 11, he was sentenced to 20 years to run consecutive with counts 6, 7, and 8. So in essence, he was sentenced to 47 years total on probation. And he started probation January 4th, 2010, which means that his probation should terminate around January 4th, 2057. So taking in light the amount of time that he has remaining on probation, we came to the conclusion to give him credit for time served and continue on probation, and to report, to have the ankle monitor placed back on, to continue with his treatment, and continue to have random drug screens.
And when you say treatment, you mean continue the treatment at the Behavioral Medical Institute?
Yes, Your Honor.
All right. Mr. Fox, how old are you?
I'm 52, almost 53.
Okay. Mr. Fox, do you have any questions or anything you want to add to this discussion?
The only question I have is, does this mean I'll get out of jail?
You'll get out of jail. Whether you get out of jail today or not is more of a paper processing thing. I need to let you know what I'm going to do with your revocation.
Yes, sir.
I have now heard the recommendation from your lawyer as well as the prosecutor. I'm going to ask Ms. Crawford if she's got a perspective from probation. It sounds like probation is willing to take you back on. Every once in a while, probation will say, this person is too much of a hassle, but it doesn't sound like, excuse me, for the most part, that describes you. And then I'll let you know what I'm going to do. And then I can answer your question about when you're getting out.
Yes, sir.
Ms. Crawford, anything from probation that's different from what I heard from Ms. Hodge or Mr. Franklin about how to proceed with Mr. Fox?
Everything remains the same. Like I said, I spoke with Ms. Hodge about 2 weeks ago and we discussed it and we agreed with everything. So it's good from on my end.
Okay. All right, Mr. Fox, in light of your admission through counsel that you violated the terms and conditions of your probation as they are outlined in the addendum, as well as your helpful recitation of what the original allegations were, testing positive for marijuana, missing group, and not reporting, I do think that the recommended revocation or sanction is appropriate. What I'm going to do, just so that the math is easier for probation to follow, is that I'm going to revoke 4 months, but you'll get credit for all the time you've been in, and then I will reinstate your balance. You've been in for more than 4 months, so you ought to get out, if not today, then tomorrow. If you are not out of jail by the end of the weekend, you should call Mr. Franklin, and Mr. Franklin will ask the jail what's going on. And if he doesn't get an acceptable answer, he'll let me know. And then I'll ask the jail what's going on. Between the two of us, we'll get you out, assuming the paperwork has gone through all the right channels that it needs to go through. So I'm revoking 4 months, reinstating the balance. And insofar as these are not already conditions of your probation, they are becoming special conditions of your probation. 1, you'll continue to wear the ankle monitor. 2, you will be reinstated with the treatment program at the Behavioral Medical Institute of Atlanta. And it was helpful, Mr. Fox, for you to tell me that you can't just show up. Probation's going to need to create that reconnection.
Sir, I don't mean to interrupt you, but it's the Behavioral Medical Institute. They referred me to a Better Tomorrow at Lenox. It's a Better Tomorrow is the actual name of the group I go to.
Okay. But did you initially go to the Behavioral Medical Institute?
Yes, I went there for an evaluation.
Okay. So what I'll say is that you are to continue with the programming that is recommended by the Behavioral Medical Institute. It may be they want to see you again because there's been a few month hiatus. I don't know. I'm not going to get in the middle of that. But it's important that I make clear to Ms. Crawford so she can make clear to the Department of Community Supervision that you're still going to be getting that kind of treatment. If it's at a Better Tomorrow or a Better Yesterday, I'll let BMI and you work that out.
Yes, sir.
You will be subject to at least 2 random drug screens per month. It may be they have you do more, but I want to make sure there are at least 2 during the first few months that you're back on probation. And then probation may dial it back. I'll let them decide that. And finally, you are going to need to take all prescribed medication and comply with any of the healthcare directives from medical professionals you're seeing. That's you plugging in with the folks at Momentum. And if they're telling you you need to take medicine A, B, and C to help with the schizophrenia, you need to take it. And if you're not, then you're getting sideways with probation, and they're gonna need to intervene. It sounds like you want to take it, and it was simply your prescription ran out and you didn't have the ability to get the prescription refilled. But you're going to need to stay current with the mental health treatment through whatever provider you're using.
Yes, sir.
And then I guess I'll just ask Ms. Crawford, it's not a directive from me because I would defer to probation here, but probation ought to think about whether it's more appropriate for you to be supervised by a sex offender officer or a mental health officer, or maybe the two would coordinate, because it sounds like one of the reasons things started going poorly this year had less to do with sex offender and more to do with you lost your job and you weren't getting medications and you were self-medicating. That's the mental health side. So I just want to make sure you're getting the support that you ought to get from probation. And that's all I've got. Ms. Hodge, anything else you'd want to see in the revocation order?
No, Your Honor, thank you.
Mr. Franklin?
Nothing further, Your Honor.
Mr. Fox, do you have any questions about what I've said?
No, sir, you've made everything very clear.
Ms. Crawford, is that true? Did I make things clear, or do you have questions about what I was talking about?
I just wanted to ask one question for the revocation probation, revocation. You said you were going to give him credit for time served. Do you know what date, or we'll get that later?
Let's see.
He was booked February 8th of this year.
There you go.
Okay.
Yep.
All right.
Arrested on February 8th, 2020. So credit from then.
Okay. Thank you.
You bet. Thank you, Mr. Franklin. I think that's it. do you need to give Mr. Fox reporting instructions, or he's already on probation, so you don't have to go through that process you go through with defendants who are being put on probation?
Tuesday.
Well, I'm gonna give him reporting instructions to report just 48 hours after you're released. You already know you report to 276 Memorial Drive, Southwest Atlanta, Georgia, and 30303. So if you're released on like a Wednesday, then that following Tuesday through Thursday, you need to report, okay?
Yes, ma'am.
Okay, thank you.
Well, but if he is released this weekend, because that's likely when he'll get out, or maybe Monday at the latest, where should he go? I mean, when should he go to that address?
That Tuesday.
That
They
Tuesday.
take intake is Tuesday, Wednesday, and Thursday.
All right, so Tuesday or Wednesday of next week, Mr. Fox, you better darken the doorway of the probation building, okay?
Yes, sir.
All right. I think that's it, everyone. Ms. Nelson, anything else?
No, sir.
All right. Thank you, deputies. Thank you, Lieutenant Hoy, for making this possible. And I'm sorry we had to jump down to South Annex. I didn't realize that one of our lawyers had the medical appointment, but it was helpful to accommodate her. So thank you all for doing that.
All right, Your Honor.
All right, take care.
Thank you, Your Honor. See you at 1 o'clock.
I'll be there.